when you have a check which you have issued for maybe to 2-3 people, okay, all your booksellers and purchasers, okay, you have transactions with them, and you have issued checks to the tune of maybe more than 3-4 lakhs without keeping an account of how many checks you have issued. It crosses this 3 lakhs of arrangements which you were supposed to do. So that time when any check comes, and if you don't have sufficient balance and already the bank has made arrangements up to 3 lakhs in your account, though that money was not available, the bank will put an endorsement or a shara in the notice which they send back with the check saying exceeds arrangement. That means their arrangement was only up to 3 lakhs, not 1 rupee more. But here you have issued checks which are much more than that. So that time it exceeds arrangement and that check is dishonored, or it bounces back and the check goes back to whoever has credited it into his account. So presumptions as to negotiable instruments. When we talk of presumptions of negotiable instruments, as to the date means that every negotiable instrument bearing a date was made or drawn on such and such a date. Now suppose I issue a check which is dated 22nd of August 2020. The presumed date or the presumption as to the date of the negotiable instrument is today. I am expected to have that amount of money in my account today when I issued the check. I cannot say that, no, I did not expect them to present it tomorrow itself, because of which I did not make arrangements. The presumption to date is made as on the date on which it is drawn. That means when you write out a check, you are expected as on that day to keep that amount as a balance, knowing fully well that you have issued a check and it is likely to be presented anytime, okay, the same day, maybe after a week, or anytime within the 3 months from which it is valid. As to time of acceptance, okay, every acceptance of a bill of exchange is accepted within a reasonable time, and where checks are concerned, that reasonable time is exactly 90 days from the date on which it was drawn or written. The transfer of the check is usually in favor of the drawee. Money transfer is made only in the name of the drawer and not anybody else. Now suppose the drawer to whom this check is given doesn't have a bank account. He cannot say, I will put it in my wife's account, my son's account, or maybe my father's account. Only the persons who have an account can have a transaction with respect to bills of exchange, demand drafts, or any type of a negotiable instrument or a check leaf. The endorsement that appears on a negotiable instrument is made in the order in which they appear. That is, every negotiable instrument has a particular format. You have the issuing bank name along with its address and IFSC code. Then you also have the date which is written on the right hand corner. It says pay to the account of so and so. It says or bearer. A sum of rupees and whatever is the amount to be mentioned is written there. And thereafter you have the bank account of that person. And next to that will either be the name of the person, or it just says sign and the signature of the account holder. And below that, the last line would be the check number. Every check book which is issued in favor of a bank customer will have a chronological number written so that bank accounts will know exactly which checks were issued to which customer. Check leaves are in booklets of 10, 25, or even maybe 50. Okay. Usually individuals take something like 10 or 25, but those who do business, the mercantile type of people who daily use about 15, 20, 30 types of check leaves, okay, they usually have big books, okay, because for a month maybe they need about more than 2 books, 3 books, depending on the way in which they transact or in the way in which they do their business. Hence, we see the Negotiable Instrument Act was mainly the Negotiable Instruments Amendment Bill, okay, of 2017. It was manifest that it was to constitute an offence under section 133 and 138, that is wherein you have your check bounce. Okay, a check must have been drawn on a particular account, and the person who holds that account, he is supposed to maintain that type of amount which he has endorsed or written on the check. The check should be issued for the discharge of any liability, either in part or in whole. When you file a case under section 138 of the Negotiable Instruments Act, you are supposed to prove that this check was issued in discharge of a liability, either in part or in whole. That means this amount which was paid to you was either as a partial payment for the outstanding, or maybe as a whole it was given to you because that person was due and liable to pay. So when you file a check bounce case, the basic thing is you have to establish that he is liable to pay. You just cannot say he gave me a check leaf. Why did he give you the check leaf? That is important because that constitutes your cause of action. The next thing, when you file a case under Negotiable Instruments Act, is that the check has to be presented to the bank within a period of 3 months from the date on which it is drawn, or within a period of its validity, whichever is earlier. Okay, so you have to present it within 90 days from the date on which it is written. A check is returned by the bank unpaid, either because the money or the amount which was supposed to be into the account of the person is insufficient to be honored. That means it does not have money because that account did not have such a balance as on the date when the amount or when the check came in, or maybe because it exceeds the amount arranged to be paid from the account of the agreement made by the banker and the bank holder or its customer. So when it exceeds arrangement, I told you the circumstances under which it exceeds arrangement. Under these circumstances, a check is returned by the bank unpaid. It could be also other reasons, because signature differs, facts don't, there could be tampering, there could be overwriting. Some banks, even if there is a little overwriting on the instrument, they refuse to honor a check and it goes back. Once you write out a check, you're not supposed to make any typographical or maybe any written corrections or any type of alterations on that. Usually when you make an alteration with regard to maybe the spelling of your figures or maybe some number, or it could be the date also, if you make a mistake, usually you have to countersign it and give it to that person. But some banks, specifically irrespective of whether your signature is on the instrument or no, they point blank refuse to honor the checks because of the material alteration. It is called as material alteration on the said instrument. So we see that the drawer of the check has to make payments of the amount said, or the money has to be paid within the specific date mentioned there, either on the very particular day when the check is issued, or maybe for whatever reasons he says, I've given you a check, but please don't present it immediately. Present it after a week, 10 days, 1 month, whatever. Ultimately, you can present a check any number of times into a bank account, provided you do not send an intimation of its dishonor to the opposite party, that is to the drawee of the said check. Once you send a notice telling him of the dishonor of his check that he has drawn in your favor, the cause of action starts, and within 30 days from the date of intimation of the check bounce, you are expected to send a notice to him. Within 30 days from the date of dishonor, you send a notice giving him 7 days to 15 days time to repay the said amount, failing which you will be constrained to file a case before the concerned criminal court in in districts or in metropolitan areas. It is before the CMM courts. Okay, there are various courts constituted just for filing of negotiable instruments, cases arising due to check bounce under the Negotiable Instruments Act. In rural areas and mofussil areas, you will notice that junior division, JMFCs and civil judge courts, okay, usually it is the JMFCs, judicial magistrate of the first class. Before that court, you will file a case regarding check bounce. So basically, what do you do when you have a check bounce? A client comes to you and he tells you that, see, my check has bounced. So what do I do? When somebody comes with a check bounce to you, to your office, the first thing that you will do is you will issue or you will make sure that the check is well in time. Okay, within intimation from the bank, 30 days from the date of its intimation from the bank. How does the bank intimation come? When your check bounces, you have to go to the bank and pick up your check leaf. Sometimes it comes by post, sometimes a message is sent to your mobile telling you that the check that you had presented for clearance has been dishonored. Or maybe someone could call you from the bank also and tell you. But most often what happens is, you know that within the next 2-3 days, your bank account shows you the amount that is credited into your account. When you realize that amount has not come, it is your bounden duty to go and find out. I presented a check for 20,000. It hasn't been credited into my account. Why isn't the amount credited into my account? So then they will tell you, ma'am, there is a delay owing to this, that, whatever reason. Or they could tell you that it has been refused, dishonored, and it has come back. So you will pick up your check along with the bank endorsement. That bank endorsement or the bank shara will tell you the reason why it has bounced. And that will have your check number. It will have the date of your check, and the person who issues this notice to you, the banker, will have his seal, signature and the date. The date of intimation is the date on the endorsement. Exactly 30 days from the date of endorsement of that bank shara, you have to send a notice to the opposite party. Sometimes what people do is they again call and tell the person who has given the check, because maybe you have presented it maybe 3 days after the date on which it was given to you. You still have another 86, 87 days. So you say, okay, let me give him another opportunity. Then maybe again it bounces. Then you give him yet another opportunity or another chance. Okay. You could give him any number of chances, provided within the next 3 months you file a case against him. Okay. Your last day would be 90 days from the date of issue of that. But why do people not keep on and on presenting the check? Because Each time you present it into your account and it bounces, the bounce charges or the service charges for having dishonored that check is withdrawn from your account. Some banks charge something like 75 to 100 rupees. Other banks charge something between 200 to 250. So every time your check is dishonored, what happens is 200 to 250 gets deducted from your bank balance. So you present it for the next 10 times, and what happens is 2500 gets easily withdrawn from your account. So that's the reason why people just wait for one or two presentations, and thereafter that money also is charged to him and he is made to pay. Okay. Now coming to what is the effect of 138 negotiable instruments and check bounce. I'll start with this topic in the next 5 minutes. You all can take a break. Uh, Coming back to the meaning of Negotiable Instruments Act. As I told you, Section 13 of the Negotiable Instruments Act, it tells us that a negotiable instrument means any promissory note, a bill of exchange, a check, which is payable either to the order or to the bearer. Whether the word order or bearer appears on the instrument or not, it is understood that only the name that is inscribed or written on the said instrument will be eligible to get their amount or whatever. The words of Justice Wills. He states that a negotiable instrument is one, the property in which is acquired by anyone who takes it bona fide and for value notwithstanding any defects of the title in the person from whom he took it. That means when you take a negotiable instrument from anybody, you take it with the assurance, believing or knowing that bona fide it is worth its value, what is written on it, without even doubting whether it will be genuinely honored or no. So that means when you take a negotiable instrument from anybody, you take it with a presumption or assumption that you have that amount in hand. It is not expected to be dishonored. That is the reason why today Negotiable Instruments Act or offences under the Act are punishable, and it is a serious criminal offence to dishonor a check, and the court in its discretion has the power to even compensate the bearer of the check double the amount, only to show people how important it is for you to keep your promise when you issue such an instrument. So this instrument, which is in writing, it creates a right in favor of the person in whose will or in whose name it is transferable. Instruments should be freely transferable from one person to the other so that there will be no type of a hindrance from either the drawer or the drawee in transacting with each other. If there is a hindrance, then it would be a big blow to commerce, mercantile transactions, and also for various forms of businesses. A person who obtains a check in good faith for a certain value should get it free from the person who has issued it without any defects. That means whatever he is entitled to recover, the money or whatever, he should get it no sooner he deposits it into his account. Likewise, when I spoke about bills of exchange and other promissory notes, you have documents like share warrants. A company, when they give you your profits, they issue share warrants, debentures, all these that come to you in the form of shares. They don't come to you as instruments of check. They come to you in the form of share warrants, which is payable to the bearer, your debentures or whatever, dividends, which are also negotiable instruments. So when you go and put this into your account, it becomes or it encashes and becomes money. The same type in the post office, you have something called postal orders. Okay, if you have to do any transaction under the RTI, right to information, as the general public, a citizen of India, you want to get any information from any government department, you have to buy a promissory, you have to buy a postal order, I beg your pardon, from the postal department. This postal order is for a certain sum, maybe minimum 100 rupees. You buy it in favor of whichever department you want to issue it. So when you issue this to that particular department, maybe you want some information from the police station. You want some information from maybe one of the ministerial government departments, for which you pay a 100 rupees postal order asking for certain details. Under the right to information, you have every right to ask for information. So when you pay this postal order of 100 rupees, you give it to that concerned department. They deposit this postal order in their bank account. This automatically becomes a negotiable instrument. It's not a check. It's not a promissory note. It is not a bill of exchange, but it is a negotiable instrument which says pay on demand to the holder of this document a sum of rupees, so and so. It could be 100, it could be 500, it could be in any denomination from 1 to whichever figure is required. So we see that the right of every person or the transferee of the negotiable instrument can sue in his name in case of a dishonor of any check. A negotiable instrument can be transferred any number of times till its maturity, that is 3 months. Once 3 months is over, it can be no more negotiated because its validity is over. The holder of the instrument need not give notice of transfer to the party liable on instrument to pay. Once somebody gives you a check, you need not keep on telling him, I'm going to present your check, so please make arrangements. Okay? You need not give it in writing or you need not give him any notice. But as a matter of abundant caution, if it is maybe a big amount somebody has given you, you can, by way of abundant caution, just call and tell that person, tomorrow I will be presenting your check, please make arrangements. Maybe for whatever reason they could tell you, no, please hold on another 2 days. We were expecting a check to come in or some payments to come in which haven't come in. So please hold on for a day or two. So maybe on the 3rd day, you could go in and put it into your account. So the right of the transferee who holds a check, that right is immediate as on the date on when the check was written out and given in his favor. There is no need for giving any type of a written notice or whatever, informing the person to make payments on the instrument, because a negotiable instrument enables the holder to expect prompt payment, because a dishonor means the ruin of the credibility of that person who is issuing that check. When your checks get bounced, automatically your credibility goes down. There is something called your CIBIL rate or your CIBIL scoring. That goes down because that shows that you are a defaulter in payments of whatever transactions. Nowadays we see there are a lot of EMI schemes. You take a loan and you buy an apartment, you buy a 4-wheeler, you buy a 2-wheeler, you buy a consumer durables, maybe whatever household necessities you require. So under these circumstances, you issue post-dated checks. You call them PDCs, or you say that I pay every monthly installment. This every month installment is called an EMI. So when you want your EMIs to be passed, what you usually do is you sign across a check, you cancel it and give it to the person from whom you are taking a loan. So they will make sure to know, they want to make sure that you have an account with any particular bank. They have something which is a mandate formality, wherein they will tie up with your bank and get an every my EMI done in your account. So automatically Every month you need not pay your check of maybe 42,000 or 20,000 or 10,000 or 8,000 towards your EMI for the purchase of your apartment, four-wheeler, two-wheeler or consumer durables. Automatically as an EMI, it gets deducted from your account till such time your loan recovery process is over. So sometimes when you don't hold on to that particular or maintain that particular balance in your account, balance of funds, your EMI bounces, your every month installment, it goes back. That means the check gets bounced. Physically, there is no check, but that transaction is a check transaction. Okay? So you have to pay EMI charges for bouncing, for refund, or maybe for dishonor of your EMI. Again, you have penal charges, you have service charges, and all the other like. Okay? So it is very important that when you have any type of these transactions, especially where your client has a negotiable instrument, he has to make sure that it is honored, failing which the consequences could be very, very serious. As I initially told you, the essential conditions of any negotiable instrument or a bill of exchange is that it should be in writing, it should be signed, the drawer, drawee or the payee must be certain. That means it should have a particular name to whom it is to pay on order or to pay the bearer. The sum payable should be written in words as well as figures. They cannot differ. It should be properly stamped or signed by the party issuing it. If it's an individual, it is signed. If it is a company or a proprietorship or maybe some partnership, it should be signed by both partners. Or proprietorship or a company should bear the seal and signature of the company as well as the person who is issuing it. The authorized signatory, has to sign it. And it must contain an express order to pay a certain sum of money, whatever should be mentioned on it. Sometimes we say so and so issued a blank check. When you say blank, it doesn't mean just a check leaf. A blank check leaf would mean the figures, the date, and the name is not written, but it has been signed and delivered to a particular person. It is signed and delivered to a person without a name, drawee's name, or the fact of figure and words is not written. So what happens at times is people go ahead and enter any sum of amount which according to their whims and fancies. Maybe you've taken a credit or loan from somebody, your client has taken maybe 2 lakhs or 3 lakhs. He doesn't repay it as promised for the next 2 years. So then what does the person who is the drawee of the check, he has your check leaf, he will put all the mounted up interest for the past 2 years. What are the penal charges? What is his advocate's charges? What is his charges for going to court or sending you a notice? He will add everything together and maybe write a whooping 10 lakhs on it. He will present it. There is a guarantee 100% that it's going to be dishonored because that person wouldn't have so much of money in his account. And then starts the process of filing a check bounce. The first thing would be to issue a notice within 30 days from the date of the intimation from your bank. Next, you wait for 15 days after the notice reaches him. How do you know that the notice has reached him? Because you send it by registered post acknowledgement due and you wait for the acknowledgement to come back. Either below the signature is the date or the post office which delivers the letter to him will have the seal. So based on that seal, you wait for 15 days and you file a PCR under section 200 of CRPC. Section 200 of CRPC deals with filing of private complaints before the magistrate. So section 200 CRPC read with section 138 in case of an individual. In case of a company, it will be under section 142 NI Act, Negotiable Instruments Act, and you will file this complaint. The complaint will be a printed format mentioning the cause title in the court of so and so, your PCR number, the parties' names, complainant and the accused, memorandum of criminal complaint under section 200 CRPC read with section 138 Negotiable Instruments Act. The complainant named above respectfully submits as hereunder. The complainant submits that the accused is due and liable to pay him a sum of rupees 1 lakh which he had borrowed from him. On demand, the accused issued a check bearing number so and so, dated so and so, drawn and such a bank, check bearing number so and so. When the said check was presented to the bankers of the complainant, Syndicate Bank, Frasertown Branch, Bangalore, the bankers of the accused, Axis Bank, Commercial Street, Bangalore, returned the said check with an endorsement, insufficient funds. On receipt of the bank intimation, the complainant has issued a notice to the accused through registered post acknowledgement due as well as speed post. Earlier it used to be under certificate of posting. In spite of the accused having received the notice, he has failed and neglected to pay the said sum. Hence, the complainant prays that this honorable court may be pleased to take cognizance of the offence punishable under section 138 Negotiable Instruments Act and take action against the accused person for dishonor of the check to the tune of 1 lakh in the interest of justice and equity. Then you will have a list of documents with all your documents supporting your case. First will be the copy of your check, the bank endorsement which says why your check was bounced. Then you have your legal notice that you have sent to him calling upon him to pay the money because he has to be given an opportunity, isn't it, to pay your money. Then you will have the acknowledgement, registered post acknowledgement to show that it has been received by him. You will also have an acknowledgement, suppose it has been refused by him and it comes back. Then you will show the refused envelope and say, in spite of him being available at this address, he has refused and sent it back. Then you will also have any other substantial documents to support what is your transaction. If it is a hand loan, you will say hand loan. If it is a business transaction, you will have your various invoices. If it is delivery note with the delivery of some goods and services, you will have that. If it is some other transaction, you will have some supporting documents, or maybe an on-demand promissory note, or maybe it was a transaction wherein he has paid a certain sum of money as a partial transaction for an agreement for sale. So you will substantiate whatever was the transaction with your other necessary documents. You will have a list of witnesses. Your list of witnesses, every PCR private complaint which is registered before court should always have a list of documents and a list of witnesses. List of documents will be all the documents substantiating the facts, circumstances in your complaint, and list of witnesses would be who are the witnesses for your case. The first basic witness would be the complainant himself. Then it would be anyone else who had the transaction. If it is somebody who has made delivery of goods and services, it would be the person who has gone and made delivery, the person who has signed the invoices. It could be the postmaster to say that, yes, the notice was delivered to him. One of the witnesses could be the banker of the accused person to say that when the said check came into the account, there was no money in his account. He will bring his ledgers. Okay. So list of witnesses should be there. And then no doubt you have your wakalat. That is the power which the complainant gives you to represent, defend, and to move his case before a court of law. And you present this PCR before the magistrate, concerned jurisdictional magistrate. How do you know which is the jurisdiction of a magistrate court for check bounce? Okay, every magistrate court in every district, in every place, every magistrate has a certain jurisdiction within which he works. This jurisdiction is based on the police stations that which come under his limit or jurisdiction. So if your check belongs to a particular bank which comes under a particular jurisdiction. Now I think I said Syndicate Bank, Fraser Town, and I said Axis Bank, Commercial Street. Commercial Street and Fraser Town come under the jurisdiction of Mayor Hall Court because Commercial Street and Fraser Town come under the jurisdiction of the Mayor Hall Magistrate. Okay, that is the 11th ACMM and the 29th ACMM. So because of which, if you file a check bounce case, it will be before the magistrate in Mayor Hall. If it is Kumaraswamy layout, Chandra layout, Koramangala, or maybe Jayanagar, whichever is the magistrate concerned, it will be before that jurisdictional chief metropolitan magistrate situated in Bangalore. Okay, so based on that, you have your check bounce cases before which magistrate court it has to be filed. So we see once a case is filed, the next step is for the complainant to come and on oath give a sworn statement. Sworn statement will state that so and so, what is the transaction, under which circumstances was the said check in question given. And you have to establish that the accused was due and liable to pay you, because liability is very important in a check bounce case. Under Negotiable Instruments Act, you have to show that so and so was liable to pay me for which he has issued a check. So in order to establish liability, primary or absolute liability, the liability of the maker of the negotiable instrument has to show that what was the reason or cause for him to issue a check. You cannot just give somebody a check to keep as security and that person cannot misuse it. There are various transactions in our day-to-day activities and life wherein you see people give people a check to keep as security for any future date transaction. Okay, examples of these could be, maybe somebody wants you to stand as a witness or a guarantee for a loan taken by somebody. Under these circumstances, what they will do is, they will ask another person to vouch for him or stand as a guarantor. And you give your check. Tomorrow maybe that person doesn't return the money and your check is used instead of his. Now here, you are in no way liable to pay that person, because the liability is not that you are a borrower. You have just stood as a guarantor. Okay, so this is not a question where you all are jointly and severally liable to make good the loss of the other person. Here you are just a guarantor for whatever money is taken as a hand loan from a particular person. So he has to establish that you were liable to pay him whatever sum or whatever. So we see that there are various inland and foreign bills of exchange also. This I am mentioning just in passing, because as you all are reading the Negotiable Instruments Act, once through you will notice that inland and foreign bills also there is a section mentioned about it. Whereas classification of bills can be classified as inland and foreign bills, which are drawn in India on a person residing in India and payable outside India. The best example would be a traveler's check, which I referred to, wherein the person in India or who is residing in India, he draws out a check in favor of somebody else so that it is paid outside, and that becomes a foreign bill. So inland bills, maybe a bill is drawn by a merchant in Delhi or a merchant in Madras or Chennai and is payable in Mumbai. So this is an inland bill which is within the territory of India, and any bills, any merchandise which is purchased or bought and wherein bills of exchange are written, I promise to pay so and so so much. All these are bills under section 132, 133 of the Negotiable Instruments Act, which are bills of exchange which are drawn in favor of parties. They should be signed and delivered in part as an acceptance for whatever transaction or whatever conveyance of goods, services, whatever has been done. So bills of exchange too, there is always a time and a demand bill. A time bill is a bill payable after a fixed time, or it is termed as a time bill. In other words, it is payable after a particular date or within a specific period. A demand bill is a bill payable at site on demand, and as soon as it is presented, it is payable immediately. Okay, usually most of our demand drafts, okay, they are just handed over the counter immediately. Transactions are done because already the money is put into the account of the concerned drawee. So there is no question of it being dishonored or coming back, because already the transaction or whatever is the consideration, it has passed from one to the other. So we notice that usually the differences between bills of exchange and check, okay, when I'm giving you all points and notes, I will do it in that so that I wouldn't want to waste time now. From what lecture I've already given you, I suppose you all have already presumed what exactly are the differences between the two. Bills of exchange, it could be negotiated and time also given, 2 days, 3 days, 5 days, 1 week. But a check, when you present it, they are expected to immediately do the transaction. No grace period or grace time or whatever is given. So it is very important that it must be done immediately. Okay. So endorsements also, on checks, endorsements are very important. Blank or general as endorsements, special, full endorsements. Sometimes it could be open, it could be self, whatever, but bills of exchange are usually in a particular person's name. It cannot be given blank, it cannot be given with some indefinite, without specification, like how you give blank checks. A bill of exchange cannot be blank. It comes into force only when the name of the concerned person is written. So we see that the effects of endorsement are very important when negotiable instruments are concerned, because the legal effects take place only because of whatever are the endorsements which are written on them. Negotiable instruments, a person cannot pass a negotiable instrument without any type of a consideration. For example, now when somebody takes a negotiable instrument from a person, it should be for a specific reason, for a specific liability, and for a specific sum. A Negotiable Instruments Act, okay, protects a negotiable instrument or provides protection to those persons who acquire instruments in good faith. As I told you, the reason why the Negotiable Instruments Act came was because people found it difficult to move from place to place when they had business transactions, owing to the bulk of coins and currency and the security purpose also. So if Negotiable Instruments Act does not provide a proper protection to those persons who acquire instruments in good faith, for whatever valid consideration or whatever, the very purpose of establishing or enactment of this act would be defeated. The very purpose would be defeated. Okay. So a holder in due course who has no means to discover the defect or whatever of an instrument which he holds with him, if he does not have a right tomorrow to encash it, then the very purpose of this act is defeated. That's the reason why it has been made punishable now under the act, and it is a criminal offense. What happens in the case of a lost instrument? Suppose the holder of a check, he loses it and he is unable to trace it, and it could be either pay drawer or it could be maybe even a blank check which he loses, a check leaf. For him to immediately take a recourse of law would be to call his bank and tell them or give instructions for them to stop payment on that particular check. He has to say stop payment. Sometimes one of the endorsements for dishonor of check could be account closed or stop payment. People stop payment when they know that the transaction should not go on. Maybe somebody has robbed their check leaf, or maybe somebody has misplaced their check leaf, owing to which they feel that it is lost or stolen. The thief of an instrument could use that same name, go and sign and take that money over the counter. Or maybe it's a blank check, he could write somebody else's name, impersonate that person, go and receive that money. So under these circumstances, to safeguard the interest of the person who has lost, misplaced, or where a check has been stolen, he has to make arrangements for it to be stopped. Any questions? Yes?
No, ma'am.
All of you are there?
Yes, ma'am.
Yes.
Sometimes we notice that instruments can be obtained unlawfully. People can even forge somebody's signature. Fraudulently, they could write out an instrument in somebody else's name. They could forge the signature of somebody, sign and intentionally see that it is passed. Signing one's own name with the intention that the signature may pass as the signature of somebody else. So that time a forged instrument has no existence in the eyes of law. A title which can never come into existence cannot be improved even if one person passes it from one hand to the other person's hand, isn't it, holder? Because it is wrong when somebody forges the signature on somebody, because when you take a check, it is taken in good faith. Suppose you lend a sum of rupees 1 lakh to somebody and tell them as a security till such time you return my money, I want you to give me a check as a guarantee. He could bring maybe somebody, his neighbor's check, put his signature and give it to you, forging his neighbor's signature or even posing that he is the drawer of the check and put his signature. You take it in good faith. So ultimately after the appointed time, maybe 3 months, 6 months or 1 year, okay, when you ask for your money, he says, I can't pay you, do what you want. So your only recourse to law would be for you to file a check bounce case. You present the check and the check comes as signature differs. This check does not belong to so and so who has given it. Or maybe it belongs to somebody else but someone else's signature is put here. So then what happens? It is no more a check bounce case under Negotiable Instruments Act, but it becomes a 420 cheating case wherein someone has dishonestly entrusted you with property, making you believe that it belongs to him, which actually isn't his. Okay? Then it would attract a penal provision and not a provision under the Negotiable Instruments Act. So we see that under various circumstances, various offences take place under Negotiable Instruments Act. Okay? The basic being people forging people's signature, people issuing checks and getting them dishonored by not having the proper money in their account when they are supposed to honor something. or a check which is given by them. So under this dishonor of check, the holder must give notice of the dishonor to the person who has issued the check. Only then can you go ahead and start effecting law and put into practice um, whatever is the legal provisions for you to recover this money or whatever. Okay, so there are various procedures as per section 138 Negotiable Instruments Act, and in our next Saturday's class I will give you two sets of notes which I will be putting up, one about the entire thing and one about in particular section 138 and 142, which deals with the dishonor of checks of individuals and companies also. So that with that, I suppose in the next one or two classes, I will be finishing this topic. Okay. Do any of you all have any questions about this?
Ma'am, for examination point of view, the NI will be like very vast or it will be like a part of something, ma'am? Is it like a
It will
very...
just be a part of something because the only two main questions that could come is regarding dishonor of checks. Okay, and NI Act, I think basically what your syllabus and other things which talk about NI Act, the main topics here would be just on what exactly is, 1 minute I will tell you.
Ma'am, also the same is not like in all the state also, I think, the subject, right?
Um, See, Negotiable Instruments Act, basically this is this extends to the whole of India, this act, okay? So every state goes by only this Negotiable Instruments Act. So what you have to know is the kinds of endorsements which are given, okay, when a check is dishonored, and what is the liability of the endorser, okay, when any check is given. What are the various types of checks, cross checks, okay, payment of cross checks specially, and payment in course of cross checks, how are those done? Dishonor of check, liability of the drawer, presumption as to negotiable instruments. And as I told you, main thing is that one section on dishonor, notice of dishonor, how notice must be given within a reasonable time. Okay, totally it's 45 days, 30 days from the date of the intimation and 15 days grace period, wherein you wait for your notice to go and either for him to reply back or to repay your money. After 15 days from the endorsement, when he has received your notice, you will file a case. Okay, and that will be on the 45th day. If you file it before the 45th day, it is a premature petition. If you file it after the 45th day, it is barred by limitation. So you have to file an application under section 5 of the Limitation Act, praying to exempt you from the delay of 1 day or 2 days, whatever. And even if it is maybe on Friday that the limitation actually started and your 45th day have lapsed on that day, and for whatever reason you couldn't, the next day being a second Saturday and Sunday, another 2 days delay, so you file it on the 48th day. Okay, no problem. You can still file an application under section 5 of the Limitation Act, saying that actually you are delayed only by 1 day, owing to the fact that second Saturday and Sunday were the intervening days in between. You were not able to do it and you will be exempted. Okay, there's nothing much. As I told you, we are in a profession where everything has an application which you can file and always overcome the situation. We are not like doctors which play with lives of people, isn't it? So however crucial, whatever may be your case, always there's an exemption where you can file an application and overcome whatever is the problem. So basically I see in your syllabus, it is the dishonor of checks, which I have really at length explained everything. But now, usually, as you know, any topic I take up, my first class is where I just cover the entire portion from the first topic till the last section. Okay. So if you have really listened to my topic today, I have covered the entire Negotiable Instruments Act from section 1 till the end, which is 47. Okay, basically there's only about 47 sections in this act. It's quite a small bare act. So next class, I will go in depth, and maybe in the next class itself, I will try to next Saturday finish the portion. Okay.
So we will not have to read the rest of the part of NI Act, ma'am.
See, whatever I have told you now, it's covered the entire NI Act. Okay, but next section, in the next session, I will be going section wise, like how I am going in CPC, and I will be covering all the topics. Okay, so in the first half of my class in the next week, that is from 7 to 8, I will finish all the terms, everything which come up till maybe 1:38. And from the second half, when I give you a 5-minute break and start off at 8:10 to 9 o'clock, will be from 1:38 to 1:47. So with that, I will finish your full topic, and I will give you maybe 2 topics I will give you notes on.
Okay, ma'am.
Yes, any more questions?
No, ma'am.
Lavin? Aishwarya? Mangala?
No, ma'am.
Yourselves.
No, ma'am.
Was the topic clear, what we spoke about? Are you aware of everything that I mentioned today, or are you all hearing things for the first time?
No, ma'am. Heard before.
More or less you all know all this? Okay, today I think I started off without recording because I see in the chat section there's a message from Shruti which says, "Ma'am, please record the session." It's only midway somewhere I noticed that the recording had been paused, because usually when I start off my class, I start with the recording, but today I'm so sorry I started off without recording it. So anyway, for those who were there today present, I suppose it is very beneficial because we more or less finished the entire
And
topic.
here we can see it is like popping out saying recording. So I think your recording is on.
I beg your pardon?
I think it's recording is done, ma'am, because I can see that recording red light is blinking.
It's blinking. No, but that I did halfway through.
Okay.
I think when I started my second half from 8 o'clock, it's then that I noticed that the recording was at pause, and I think then I started recording it. But anyway, I hope you all are able to get this topic. If you all are not able to, if you all have missed out on something, no problem. I can again start from the beginning, okay? As I told you, I don't prepare and come. I just start off from the beginning to the end. So with one stretch, I just go over the entire topic, so it shouldn't be a problem to even once again give you everything. Okay? With this, thank you so much. Today we are closing 4 minutes earlier. All of you all have a nice weekend. Have a happy Sunday, and see you again on Tuesday for CPC. Good night.
Thank you, ma'am.
Thank you, ma'am.
Welcome. Bye-bye.